Hello, everyone. I want to thank you for taking time out of your Sunday to learn with us. My name is Shannon, and I am the Operations Development and Program Coordinator for the clinic. We work as a team of four. So we have Camila, who is our Office Administrator, Development Assistant, and Philanthropy Coordinator. We have Shamika Samuels, who's our Marketing, Communications, and Special Projects Coordinator. And we have Matthias Samuel, who's our Finance and Information Technology Coordinator. He is behind the scenes. I don't think he'll be able to show his face right now, but he works with us. I just want to give you a little background on the clinic. We are a Black-led, not-for-profit collective that provides free seminars referred to as clinics. And our mission is to curate programs which will educate, unify, and promote social and economic independence within the Black community. And our target demographic are Black adults between the ages of 25 to 45 living in the GTA. And our clinics are delivered through an inclusive, anti-oppressive, and culturally specific framework under the pillars community wellness, economic advancement, and legal and social support. So today we have a very informative session prepared, and we will have designated question periods. If questions come up during the presentation, you can submit them to Camila in the chat. Camila, wave your hand so they know. Yes. And or at the designated question period, and we have a few throughout the presentation, you can, if you want to speak, you can raise your hand and we'll unmute you so you can ask your question to the presenters. Please note that the clinic is being recorded, so be mindful of the information that you share during the session. It's also important to note that the information that is being presented by the lawyers today in this session are for general informational purposes only, and it does not constitute legal advice, okay? So neither the presenters nor the clinic are providing any individual guidance to you. It is just, so it's recommended that if you have in-depth questions about your situation, that you seek out a licensed legal professional to talk about your specific issue so that they can tailor it to you specifically. Okay, so this is not legal advice. All right, great. So I'm just going to go ahead and introduce our presenters today. First up, we have Danielle. Danielle is an in-house litigation counsel for a leading North American trucking and logistics company. She is a barrister and solicitor licensed by the Law Society of Ontario and was called to the bar in 2020. Danielle's practice consists of predominantly employment and labor law, and she completed her law degree at the University of Ottawa Faculty of Law. Prior to her in-house role, Danielle represented employees as a litigation associate at a well-known boutique employment law firm on Bay Street, and this experience solidified Danielle's passion for employment law. In her current role as an in-house counsel, she assists her employer to navigate employee terminations and layoffs, constructive dismissals, unjust dismissal claims, human rights claims, and union grievances, as well as other civil and tortious legal issues. Her client employs federally as well as multi-provincially regulated workers and employees. Accordingly, Danielle represents her client at various levels of provincial courts, federal adjudication, and both federal and provincial human rights tribunals. Danielle's employee side experience enables her to implement authoritative and, where appropriate, equitable approaches to her litigation strategies. Her proficient understanding of employees' positions allows her to give well-reasoned advice to her clients. She is a zealous advocate, keeping her clients' interests centered throughout the process. She approaches her work with a listening ear, a keen eye, and is result-oriented. Outside of work, Danielle is passionate about educating and empowering her community with regard to their employment law rights and obligations from the hiring process to termination of employment. We are so grateful to have her here to share her expertise. So Danielle, thank you for joining us today. And our second speaker is Osaro Obaseki. I hope I said that right. Osaro, I'm so sorry if I did not. Um, Osaro is a Toronto-based labor and employment lawyer at Ogletree Deacons International LLP. He was called to the bar in 2021 and is licensed to practice in British Columbia and Ontario. Osaro has a broad employment practice that spans across various sectors and INIS. He often advises on workplace policies, severance disputes, human rights issues, reasonable accommodations, and employment standard issues. While Osaro's current practices focuses on providing legal services to employers, he previously worked for a prominent plaintiff side employment litigation firm where he advised and represented employees on a variety of employment issues. Having worked for both employers and employees, Osaro takes a balanced and pragmatic approach to resolving workplace issues. So again, we are so fortunate to have him here to share his expertise. They have an excellent presentation planned for you. It is information heavy, so if you have a pen and paper, that would be awesome for you guys to write notes and to keep track of maybe your questions. And without further ado, take it away.
Good afternoon. So today we're going to focus on several topics. First, we'll talk about jurisdiction, federally and provincially regulated employees and what those types of employees look like, the industries they may be in. Human rights. So we'll be talking about what human rights looks like in Ontario and recourse under your human rights in Ontario. Overtime and the right to disconnect, the Employment Standards Act and leaves of absence within Ontario, Ministry of Labor complaints, navigating termination and constructive dismissals, and when and how to get legal advice. So all of these topics will be covered under Ontario jurisdiction. So let's get started. Let's talk about jurisdiction. So both the provincial and federal government are able to enact employment laws for the country as well as the different provinces. Most employers and employees are governed by the provincial employment regime or legislation as per their province. The federal government has jurisdiction over federally regulated industries. So what that means is someone working for a federal employer does not necessarily mean that you work for the government of Canada. It just means that your company or employer is federally regulated, so they're engaged in a federal undertaking. And we'll go through what those types of industries look like in the next few slides. Which sets of laws apply to you is determined by the business of the employer and not the duties of the employee. As we mentioned, this presentation is going to focus mostly on provincial employment regimes, specifically Ontario, as that's the province that we're in. So just to go through a list of federally regulated industries, just to make sure you know where you fall under jurisdiction. Federally regulated industries are governed under the Canada Labour Code. There are different employment standards under the Canada Labour Code. We're not going to focus on those today. We're going to focus on, as I said, the provincial legislation for Ontario. But be aware if you're governed by the federal law. Always check your employment contract and obviously have a conversation with your employer to note if you are federally regulated or provincially regulated. Some of the industries, this is not the full list, but these are some of federally regulated industries in our country, such as banks, like your RBCs, your TDs, your BMOs, radio and television broadcasting, telecommunications, such as TELUS, Rogers, etc., shipping, airlines and railway companies, interprovincial trucking, transportation, like trucking industries that transport items interprovincially, grain elevators, feed and seed mills, First Nation band councils and self-governments, crown corporations, i.e. Canada Post, and the nuclear industry. So now that we've spoken about federally regulated industries, we can talk about the main topics of our discussion, helping you guys in terms of recourse. And the number one thing I think that's important to know is about your human rights. So every Canadian jurisdiction has legislation that established, among other things, a comprehensive system for investigating the resolution of complaints. And excuse me, and the legislation covers the workplace as well as other social areas such as housing or service. We're going to be focusing on the workplace in this particular presentation. And every person has the right to equal treatment with respect to their employment without discrimination. So there are various types of human rights, and there are different types of prohibited grounds that you cannot be discriminated against. Under Ontario, we have the Ontario Human Rights Code, and under section 5 of that code, it lists the different prohibited grounds that you cannot be discriminated against under your employment. That would be your race, your ancestry, place of origin, color, gender expression, ethnic origin, citizenship, family status, sex, sexual orientation, creed, marital status, and record of offenses. And as you can see, this list is quite extensive and covers variations of different things that people might necessarily think merge together, like your race or your ancestry, your place of origin or your ethnic origin, your sexual orientation or your sex. These things intersect, but they're not always the same. So under the Human Rights Code in Ontario, you cannot be discriminated against by any of these grounds. So discrimination occurs when an employer adopts a practice or a rule that on its face has an adverse impact to the employee or a group of employees based on a prohibited ground. That could look like a workplace rule, policy, procedure, requirements that you have to follow at work, qualifications or factors that may not be openly discriminatory, but which create barriers to achievement and opportunity, and they may actually violate the statute. So we look at specifically, not necessarily overt acts of discrimination, for example, sexism, ageism, or racism, but the inner workings of the company can sometimes also create these barriers and can be discriminatory. One thing we always have to note, though, safety is a trump card for any protected ground. This means, for example, if there's an issue with any of the human rights grounds that we're talking about, but the safety of the company and the safety of the employee and people who interact with the employee are paramount, then unfortunately that would trump any kind of discrimination claim potentially. So common forms of discrimination, which obviously would impact our community, are racial discrimination, hiring and retention, microaggressions, and uncomfortable interactions. So if you're, for example, in an interview and you're asked particular questions that are racist, while you're within your employment, there are, seemingly discriminatory actions happening to you based off of your race. Microaggressions being questions that are unwarranted and grounded in racial discrimination, such as asking somebody where they're from, highlighting someone's hair every time they come in and saying racially or uncomfortable comments to that person. And also racial discrimination occurs in promotion and institutional barriers, right? So people not being able to be promoted, even though they have the qualifications and the tenure to do so, but people who are less tenure and less qualified are being promoted. And it's clear that it's the people of color who are not being promoted. In addition, background checks where they're not needed, those are forms of discrimination. Disability, of course, whether that's a physical disability or an invisible disability. There are some disabilities such as mental health disabilities or other cognitive or behavioral disabilities that people may not know about when they look at you. They may not see it right away. But if you're being treated adversely or different because of that, that's still discrimination based off of a disability, as well as family status. If someone is a single parent, or if someone has, for example, daycare issues, and the company may not be accommodating to those things, that could qualify as discrimination under family status. So accommodations. There is a duty to accommodate that an employer has to take on, and it may require them to assume additional obligations and expense to promote an integrated workplace. The duty to accommodate places the onus on the employer to prove that they, the employer, could not have accommodated without undue hardship. Undue hardship is essentially a very high threshold in which the employer is not able to accommodate an employee, right? Whether it's not feasible financially, whether it's illegal to do so, or whether it's just not something that they can do based off of the type of role that that individual has. And it varies with every different employer and every different industry. So that's the threshold of undue hardship will be specific to your relationship with your employer and your role. And the duty to accommodate also requires the employee to assist and cooperate by providing information relevant to meeting their needs and to accept the reasonable accommodation provided. So accommodation and working to accommodate any type of, whether it's a disability, or whether it is a family status issue, those types of accommodations need to be worked out with the two parties. So the employer and the employee have to come together and come to a good accommodation that makes sense for both parties. It may not be the perfect accommodation, but the point is that it's worked together with both parties and it makes sense and it's feasible, right? It has to be reasonable, not perfect. So how do you deal with discrimination? Well, the first thing that you need to do is speak up. Always make a formal complaint if you feel like you've been discriminated or harassed at the workplace, whether you think it was just a microaggression or it was something more overt or an issue with promotion and dealing with team members. Always make a formal complaint. Employers are responsible for their response to discrimination complaints, but you as the employer are responsible to bring the complaint to, whether it's your supervisor, or if it's involving your supervisor, escalating it. So as we said, don't escalate. Don't be afraid to escalate if the complaint revolves around or is inclusive of your supervisor. Make sure that it is brought to the correct individuals, whether that is a supervisor of your supervisor or the manager of your supervisor or human resources. Also be persistent, but also be patient. Obviously make your complaint be known. Follow the adequate processes that you need to follow to make that complaint, but also be patient. Sometimes these things take a little bit longer than we would like them to, whether that's in the workplace or through the next stages of recourse that you may take. And I think the most important thing to note is to make sure everything is in writing. And we'll talk about different types of evidence that you would need for a formal complaint that goes beyond the workplace. But even within the workplace, start there, documenting everything, make sure it's in writing. Now, we've talked a lot about discrimination, and it's a very triggering topic for some, I think. So more than happy to take questions at this time.
So I'm just looking in the chat. I'm not seeing any questions that have come up yet. And if no one has any questions yet, you're still warming up and getting used to the idea, we can move forward.
Yep, and we're still going to talk about the tribunal next, which may have more questions come from that topic. Okay, great. I'm glad I'm being concise and you guys, it was clear in that regard, so that's good. So what kind of documentation do you need if you are going to bring a claim to the Ontario Human Rights Tribunal? Now, the tribunal is a tribunal for individuals to bring harassment and discrimination claims under any of the protected grounds that we mentioned before under the Human Rights Code. And it is one of your effective pieces of recourse that you can have. But it's important to have documentation. And as I mentioned before, make sure everything's in writing, but more specifically, documentation is very important evidence for your Human Rights Tribunal Ontario claim, HRTO for short. Document all incidents of any harassment or discrimination that happens. Document all complaint meetings with your superiors or human resource department, whether they're in person or virtual. And always send a follow-up email. I think it's very important to make sure that you send a follow-up email to bring the incidents or more than one incident to the correct superior's attention, to confirm in writing what was said by each party in the complaint and any subsequent meetings. It's always good to say, this is the conversation we had, and make sure it's in writing so that there's no issues in regards to the truth of what happened. And it also ensures that you've papered yourself throughout the discrimination or harassment that you've experienced. The HRTO obviously have adjudicators who make decisions, but in order for them to say that you've actually been discriminated based off of a protected ground, they need to have evidence of the same. And sometimes it's hard to have evidence if it's like microaggressions or incidents that you think are small, but no incident is too small. No specific instance of discrimination is too small. So always make sure to document that. And some other types of evidence that I think is very important in regards to an HRTO claim are any handwritten notes you take at a meeting. Make sure you're making those notes as you're speaking to whoever it is that you're addressing in the meeting. Any anti-discrimination or harassment policies given to you by your company, it's good to have those on hand to say this is the policy that they had in place, and obviously they violated this policy. And if they don't have a policy, that says a lot too. So whether they have it or not, it's important to have that information. Now, a lot of people ask about recordings, and I know a lot of people tend to think it's the best piece of evidence because it's everything caught right in the act, right? Whether it's the discrimination, which may be rarer, or a meeting that takes part with human resources or a manager. But it is important for you to know that you need two-party consent to record individuals in Ontario. So don't record anyone without their consent. I know people still do it, but you should be getting that consent. And if the individual doesn't give you consent to record the meeting, for example, then just make sure you're taking good notes, whether during the meeting or immediately after the meeting or the incident. Additionally, personal diary notes. I know people, will leave a situation and make their own personal notes, whether it's on a notepad or in a diary or a space that, feels safe for them. And that's totally fine. However, they're not necessarily useful pieces of evidence if you're not actually bringing that information to your supervisors or your managers. You have to let people know at the workplace. And when I say people, I mean your manager, whether that's your direct manager, supervisor, or HR, know that there is discrimination going on, whether that's based off of your disability, your age, your race, your sex, any of the items that are protected grounds under the code. Always bring incidents of harassment and discrimination to the attention of your superiors. Even if they don't necessarily investigate the incidents, and you feel frustrated because they're not investigating the incidents, which oftentimes can happen, it's still important that they were notified and it was documented. As I said, the onus then becomes on them, becomes their onus and their burden to assist you in navigating that discrimination. So I've been talking about the HRTO a lot, which is the Human Rights Tribunal in Ontario, and it's a very great resource and point of recourse and forum for people to bring claims of discrimination, and harassment based off of protected grounds if they believe they have been discriminated based off of those grounds. And so there's some good pros about it. There's some good reasons why you can bring a claim to the HRTO. One is because it's very employee friendly. Navigating the system is very easy. And they also have a clinic that will kind of help you navigate your claim, provide you more information. So they have a lot of resources for employees to navigate the tribunal system on their own. The process is relatively easy to understand, and there's no cost awards risk against you. What that means is, in a general court case, for example, if one party is a party who is not successful in their claim, they're the losing party, they may actually have to pay the legal fees of the other party. So these are called cost awards or cost consequences. And when we are navigating through the Human Rights Tribunal, the Human Rights Tribunal of Ontario, the HRTO, there are no cost award risks. So it's less financial risk for you as an employee to bring a claim through the HRTO. You also don't need a lawyer to bring a complaint to the HRTO. You can bring a claim as a self-represented individual. And once a prima facie case of discrimination is established, so once it is found that there is a case of discrimination against you, the tribunal has found that, then the employer now bears the onus to prove that that treatment against you, so that adverse or negative treatment, had nothing to do with the protected ground. So now the employer has to go through their evidence to prove that they didn't treat you adversely or harass you based off of any of the protected grounds. Although you don't need a lawyer to navigate the Human Rights Tribunal, I would suggest that you always speak to a lawyer before bringing a claim, even just to get a consultation, to get a high level of your claim and a little bit more legal information in terms of navigating it on the onset. It would be great. You don't necessarily have to use or retain their services, but it's also good to just have that conversation with a lawyer before you bring a claim. Now, just as there's pros with the HRTO, there are also cons. There's a current backlog. So unfortunately, the HRTO forum was designed to be timely and bring timely resolutions, but based off of recent resource issues, and let's be honest, COVID is still trickling down, complaints are taking longer than ever to be heard. I can't tell you an exact time in which a HRTO claim will be heard, but it could be years. And that's the unfortunate part in that regard. The proceedings can involve disclosing a lot of personal information that could be triggering or traumatizing or re-traumatizing, and personal storytelling, which can also be emotionally draining. So you just have to be prepared for the rigorous back and forth in terms of disclosing your personal information when you're bringing this type of claim. And as we mentioned, the time to bring the claim might be long, but the process of the hearing process might be long as well. You don't need a lawyer to start the complaint, as I mentioned, but it's also hard to proceed to a hearing without one. The process is easier and navigating might be easier with the assistance of just some legal advice, but proceeding to a hearing, you want to have the best foundation and the best strategy in terms of moving forward. So particularly at a hearing where you may be needing to cite case law, delve into complex legal issues, and the employer may actually have a lawyer who is representing them, it's probably best to just have equal standing in regards to the claim, right? So having a lawyer at the hearing stage specifically is probably the best way for you to have a good strategy in your claim. So if you start a complaint and take it to the hearing stage, as I said, it's much harder to bring a lawyer in at the end. So when you're getting that consultation, legal information, really make a concise decision on whether you think that you should be getting a lawyer involved. Obviously, there are people who have brought claims and they do all the work, they do the research, and they really, put a lot of effort into their claim, which is great. But if you can have a lawyer assist you, that might take away and alleviate some of that pressure, specifically if you have other things going on in your life. And again, we'll always say it, and it's probably going to be on many slides, but always speak to a lawyer before filing your complaint. There are also timelines that you should be aware of when thinking of going to the HRTO for a claim. You should file your claim within 1 year of the alleged discrimination. If there were multiple instances or occurrences of the discrimination, you should file your complaint within 1 year of the last occurrence. The HRTO can accept late complaints in certain circumstances, but getting legal advice as early as possible to understand how much time you need and whether or not you can file a late complaint is also very important. And that's why having a lawyer assisting you in navigating the claim or representing you in the claim is important, because they understand some of the timeline issues that may come up and may be able to help you navigate out of a potential timeline issue. So now Osaro is going to talk about the Employment Standards Act, which is the Ontario legislation.
Great. So every Canadian jurisdiction has what we call minimum standards legislation. And like Danielle said, in Ontario, it's something called the Employment Standards Act, which I'm sure everybody's heard of. And then for the federal jurisdiction, it's the Canada Labor Code. And what this legislation does is it sets out the bare minimum that employers have to give to employees. And it kind of acts as like a guide for, where the employment relationship starts. And everything in the ESA, because it's a minimum, can't be sort of contracted out of, or your employer can't negotiate with you when it comes to your ESA entitlements, unless it's for something over and above what the ESA provides. So, for example, if your employer says, or if all employees are entitled to 2 weeks vacation, that means that your employer has to give you at least 2 weeks. If they want to, contract, if they want to put into your contract that you get 3 weeks or 4 weeks, that's totally fine. They can't give you less than 2 weeks. And then certain categories of employees can be exempt from parts of the legislation of the ESA, but those are sort of very specific, and we'll go through a couple examples of them. But my advice is to sort of make sure that if your employer tells you that you're exempt or you don't get, an entitlement, look into it, speak to a lawyer, ask questions about it, because all the exemptions are narrow. So under the Employment Standards Act, as most people know, every employee is eligible or presumably eligible to overtime pay once they've worked over 44 hours in a week. If you're a federally regulated employer, that's an employee, it's over 8 hours a day. And many, or the legislation, the Ontario Employment Standards Act, allows employers and employee to average your overtime over a set number of weeks. So, for example, if you work 50 hours 1 week and then 30 hours next week, that's an average of 40 hours a week. And in that scenario, you're not getting overtime. That's what we call an overtime averaging agreement, which I think we'll talk about more in a little bit. But there's a number of ways in which an employer might not have to pay overtime. The other method is bank time. But again, all of this has to be done like in a particular way, and that's usually via a written agreement. And with bank time, you should be getting the same sort of like rate, which is time and a half, and it can't be expired. So if the employer, for whatever reason, you don't end up using it and you leave it, then the employer has to pay that out. Okay, so I think I mentioned overtime exemptions previously. So most provinces have, a series of exemptions. The most common one is the sort of manager supervisor exemption, and that rule essentially is that, like, if you are a manager or supervisor, you're not entitled to overtime, but that's only if you don't do sort of if you don't do regular work or non-managerial supervisory work on a regular basis, and if you're in doubt about whether or not you qualify, then you assume that you're non-exempt. The other sort of way, the other exemption is averaging agreements, which I alluded to before, and that's when you and an employer enter into an agreement that says that rather than assessing your overtime at 44 hours in a week, that you will average that. Regulated professionals, so a lot of if you're a professional who's regulated by a college or some regulatory body, a lot of those classes of workers are exempt as well. And then finally, IT professionals, but only those who are applying specialized knowledge and professional judgment. And so again, like when in doubt, if an employer says that you are sort of exempt from overtime, it's worth asking follow-up questions and going to the ESA to see if you sort of agree. And if not, or if you're unsure, then speak to a lawyer about it. Okay, so with the manager example, the manager exemption, we have an example here. Mark, who works at Second Cup and is a manager, he supervises the day shift and usually works out of the back office. But every day from 12 to 1 p.m., he helps out the baristas with making coffees and taking orders. Because it's busy during the lunch hour. There's a higher staffing need at the front counter, and so he helps out every day. So in this scenario, Mark is entitled to overtime and or non-exempt from overtime. And the reason is because he regularly does non-supervisory work, which means he doesn't qualify for overtime. And just to clarify, Mark is owed overtime not just for the hours that he's working as a barista, but like for all of his hours. Because in order to qualify, you have to be sort of a true manager who only does managerial and non-supervisory, managerial and supervisory work. Okay, and questions?
Okay, so pausing for questions. There's one question that I have in the chat. Can you provide, and this is both for you and Danielle, whoever would like to answer, can you provide an example of reasonable accommodations that employers are required to make for employees with an invisible disability?
Okay.
So it's a little tricky.
Yeah. So as I mentioned, invisible disabilities can be so many things, right? And oftentimes require, for example, somebody to have a specific lunch break or work a specific shift, or have specific breaks within the day if they have, for example, a cognitive disability. So really you're working with the employer to find something reasonable, which means it assists you in accommodating your disability, but it does not disrupt the company to the point that they cannot conduct their business, right? So definitely having a good conversation and building that rapport with your employer in regards to providing as much information about your disability, whether that's doctor's notes or assessments that you took, right? Just to let them know these are the things that I've been told based off of my medical assessment and diagnosis that I'm required to have in order for me to fulfill my duties at this role, but also for me to take care and manage my disability, right? It's really a balancing of the two needs, right? And also understanding that there's no perfect resolution. It may end up being a really good resolution for you depending on the company's needs. But there may be some things that you have to make some concessions on, as long as it's not exacerbating or making your disability worse, of course, right? And so if you do have instances where you have an invisible disability and your employer is not accommodating you reasonably and it's not assisting you in any way, again, we'll use the token sentence, speak to a lawyer to see what legal information or advice they can give you to navigate that situation. Does that answer the question?
Okay, so while I'm waiting for the person to respond, if they feel like that answers their question, there is another question that came in that is kind of associated with that. Are your managers allowed to disclose your disability to others?
So, first of all, you don't even have to disclose your disability to managers. Once you disclose your disability to managers, it should only be in the realm of which you're working that you are being accommodated. They should not be disclosing your disability to anyone. Your accommodations are based off of whatever information you provide to your managers, and that should be confidential. They should only be accommodating you based off of what information you provide. Them telling other managers about your disability, specifically managers who are not going to be involved in your accommodation, is a no-no.
Okay.
Yeah, and just to add to that, so the first question, invisible disability example, let's say I have, I walk fine and seemingly fine, but I have a back issue. I can only, and I have a desk and I have a regular desk. I need a standing desk because, I have to stand every 25 minutes. That's an example. Another one could be like I have a sort of like a neurological issue that requires me to, take a break or like walk outside for, 10 minutes every 2 hours. Those are sort of like accommodations that an employer can make. And then to add to Danielle's point about the second question, yes, all you have to sort of disclose is your restrictions and like what your requirements are, not necessarily the underlying reason why. And that should only be shared with the people who are involved with, either organizing the accommodation or sort of determining how to best accommodate you, which usually means, if you're a big company, that usually means, HR or a subset of HR, and not the wider company. Like if somebody's being told about like your sort of health information, there should be a justified reason why, and it should be because they're involved in the accommodation process in some way.
Yeah, and I'll just add to that, as I mentioned before, health and safety is the number one main priority, right, in any workplace. So even if you need to be accommodated for a certain disability, for example, maybe a trucker who needs to be accommodated for a visual disability, or maybe they have a disability with their back or their foot, it's fine to accommodate them. But if accommodating them causes a safety issue within the workplace for that person or people on the road who they may be interacting with on a daily basis, that's where we kind of bring the reasonableness factor. Is this a reasonable accommodation? Does it work, or does it reach to the point of an undue hardship?
Okay. There is one other question. I think someone would like to have the example about overtime clarified. So please, could you repeat the example about overtime?
Yes, I definitely can. So Unless you want to just go back. Yeah. Okay. So again, let's say we have, you know, an employee, Mark, who is a manager at Second Cup. Because he's a manager, his employer isn't currently paying him overtime. Or let's say his employer isn't paying him overtime because, you know, under the Employment Standards Act, managers generally are not eligible for overtime. So let's say Mark works, you know, 50 hours a week, and he gets paid straight time for that time because he's a manager. But Mark, you know, every day, let's say he works Monday to Friday, 10-hour days, every day from 12 to 1, Mark is not in the office, but working alongside the people that he's managing. So making coffees, you know, taking orders, doing stuff that's non-managerial. The fact that he's doing that every day makes him eligible for overtime because he's no longer, the fact that he's doing that every day makes him not a manager for the purposes of the Employment Standards Act and overtime. Does that sort of make sense?
Okay, so the person that asked me that question, if you could just let me know if that clarifies things for you a little bit, that'd be greatly appreciated.
And I'll just note on that point, the management exception is very subjective. We won't go into the rigmarole of case law that is like so on the opposite end of the spectrum for who is a manager and who's not. You can be called a manager on paper and still not be a manager for the purposes of overtime exemptions. The title does not dictate whether you are a manager or not. It's the role and the nature of the role. So all the different functions of your role, and even if some of the items or the functions of a role are supervisory, if there's items that are non-supervisory, then, you know, the argument is you are not exempt from overtime and you should be paid overtime.
Okay, the person that asked said, yes, thank you very much. So the question was answered. Okay, just a reminder to everybody, as you have questions, you can just direct message me in the group and I'll get our facilitators to answer the questions at the next appropriate break. All right, thank you, continue.
Okay. So I think we're at the right to disconnect. Okay, so the ESA, as far as the right to disconnect goes, which came in a couple of years ago, doesn't actually require, you know, the employer to give you, it doesn't create any substantive rights around, you know, not working after your allocated work time. What it does do is that it makes or requires certain employers to have a written policy around quote unquote this like right to disconnect and provide that policy to its employees. The policy has to like have, you know, a number of things, including, you know, how you like your work time and communication expectations after work, so on and so forth. And so that policy is supposed to help you sort of figure out, you know, how to respond to like emails, for example, when you're off the clock. So if you work a 9-to-5 job, and then, you know, some people in your office usually, you know, send emails at 8 o'clock or 9 o'clock, or, you know, after hours or after the hours that you're being paid for. The sort of right to disconnect policy that you're being provided is supposed to help you figure out, you know, what to do with that. And so if you are still working, if you are, you know, find yourself either checking your email or, you know, having to respond to emails because they're urgent or whatever the case may be, and you're not being compensated for it, you can, you might be able to make a administrative labor complaint for overtime. And if you're in that scenario, the two important things: one, keep careful track of, you know, how much time you're spending sort of after hours or outside of your regular working hours or your paid hours, doing work things. And then two, go to your employer and ask them, you know, hey, I'm in this situation, or you know, my hours are supposed to be 9 to 5, but I often either leave late or not leave late, but like, after I go home, I get calls and messages and emails and things that I'm forced to respond to them. Like, how are we going to deal with that? I.e., are you going to pay me overtime, or are we going to figure out a way that so that like I'm not having to do that? And so that's sort of the sort of key points there. Okay. Vacation. So before I jump into this one, I just want to say this is a very, very sort of like confusing and complex area. And that goes for employees, employers, and lawyers even. There's going to be a lot of numbers here and a lot of examples here. I'll try and slow it down and make it as clear as possible. But of course, ask questions, sort of throw questions in the chat as things come up. And so generally under the Employment Standards Act, every employee is entitled to vacation, which is divided into two parts. There's vacation pay and vacation time. And so we'll primarily focus on vacation pay. But I'll touch on vacation time to explain, why it becomes very confusing. So vacation pay, every employee is entitled to 4% of their total wages as vacation pay. So for example, if for every $100 you earn, for every $100 you earn in wages, you're owed an additional $4, which is 4% of $100 as vacation pay. If you earn once you earn $1,000, you're owed an extra $40, $10,000, $400, so on and so forth. And then that 4% rate increases to 6% once you've been at an employer for 5 years. So again, same thing. You earn $100 in your regular salary. That means you're owed an extra $6. You earn $1,000, you owe $60, $10,000, $600, so on and so forth. And so the example that we have here, which we'll refer back to throughout, Brianna, who's our friend that's going to help us understand vacation pay. Let's say she works a new job, or she just got a new job, very excited about it. She started on January 1st of this year, and she earns $60K a year. By June 30th, which is 6 months in, she would have sorry, I forgot to say, vacation pay starts accruing like right away. So yeah, Brianna, she earns $60K a year. She's worked for 6 months, which means that she's earned $30,000. She's owed an extra $1,200 in vacation pay. And how we got to that number is 4% of 30 grand is 1,200. So next slide. The other concept, which again, a lot of employers sort of combine them, but they're not the same, is vacation time. And with vacation time, you're essentially every employee who's governed by the Employment Standards Act is entitled to 2 weeks off per year for the first 4 years, and then 3 weeks off after 5 years. You're not entitled to 2 weeks paid off or 3 weeks paid off. That's essentially how it works out. That's essentially how it works out. But they are two very separate things. And whereas vacation pay, the 4%, you start earning, as soon as you start working. It's 4% on every dollar that you earn. Vacation time, you earn essentially 1 year after 1 year after you start. So for example, if Brianna starts a new job, or Brianna started a new job on January 1st of this year, then by December 31st of this year, she gets 2 weeks of vacation. Vacation time isn't sort of accrued, or it's not that she gets 1 week 6 months in. She just gets 2 weeks at the end of the year. Of course, her employer can give her 2 weeks before she completes her year, but that's how vacation time works. All that to say, vacation pay and vacation time, vacation pay and vacation time are related, but they're not the same. And you have to make sure that your employer is keeping careful track of both and making sure that you're getting both. And we can talk about how an employer gives vacation pay specifically. But the point that I really want to get across here is that just because you're getting vacation time doesn't mean that you're getting all of your vacation pay. And so, yeah, next slide. Okay, so again, we're going to leave vacation time alone for a second and just talk about vacation pay, because that's the part that usually gets missed. So there's three ways an employer can, give you your vacation pay, which again is the 4%, the 4% of the 6%, but we'll just use 4% for this. They can either give you a paid vacation. They can sort of pay you out on every single paycheck, which we're calling a vacation payout, or they can bank your vacation pay. We'll talk about how each of these three applies. And so the paid vacation is probably the most, common method. And this is when you get your regular salary while you're on vacation. So it's as if, you're working. So this method works really well for salaried employees, or employees who have the same paycheck every month. And if you are an hourly or part-time employee and your hours and your pay vary, then this has to be based on like your sort of standard work week. The example that I have here, if we take Brianna again, who just started, at the beginning of this year, and she earns $60K a year, which is, $2,500 semi-monthly. On the 1st and 15th of every month, she gets $2,500. She takes a 2-week vacation, 6 months into the year. And she gets her usual paycheck, which means that, it's as if she was working and she gets her usual $2,500 on, July 15th to July 30th. That means that Brianna's getting a paid vacation. And by January of next year, Brianna would have received her vacation time and her vacation pay, which is roughly $2,400 a month. I know the numbers are very confusing, but again, in this scenario, Brianna is just getting her regular pay as she goes on vacation. The second way that your employer can give you your vacation payout, or they tend to give vacation, is through vacation payouts. And so in this scenario, your employer just gives you the 4% vacation accrual on every dollar you make or on every single paycheck. This method is sort of like more reliable and precise. And it works really well when your pay is not the same every month, or your hours differ every week or every month and whatnot. But this means that when you do go on vacation, you're not getting anything. Or it's not that you're not getting anything, you've already gotten your vacation pay. So in this example, Brianna, rather than getting, $2,500 a month, or sorry, $2,500 every 2 weeks, she gets $2,600 every 2 weeks, which is the $2,500 that she earns in wages and the extra $100 for vacation pay. And if she's getting that, that extra $100 throughout the year, or on every paycheck, that means she's not going to be getting anything when she schedules her vacation for the year. And then the third scenario is banking vacation, which is essentially the same as the last method we talked about, except rather than giving you the $100 every month, the employer just keeps track of it and banks it for you, and then pays it out to you as a lump sum, either when you request it or when you decide to go on vacation. And so example I have here is if Brianna notifies her employer that she wants to take a vacation in July, her employer will, and then she says, I want my 2 weeks. I want to take a 2-week vacation in July. Her employer will say, okay, you've been here for 6 months. You've earned $30,000. 4% of that $30,000 is $1,200, and so that's what your vacation pay is. And then she has a choice of either getting that paid out to her so that she can use it on her vacation or for her vacation, or she can say, I'll save it for the next vacation, the end of the year, another time, so on and so forth. But in this scenario, if she does take out her $1,200, and then goes on vacation in July and takes no other vacation, by the end of the year, her employer has to ensure that she gets, the rest of her vacation pay, which is the other $1,200. Because again, she earned $1,200 because she at the 6-month mark, because that's 4% of $30,000, which is like half a year's of work for her. Okay. Okay. And all that to say, there's sort of two ways, vacation gets sort of messed up or incorrectly paid, or vacation pay gets incorrectly paid. The first one is when you are doing the paid vacation method, or when your employer just pays you for your vacation, and says, take time off, we'll just continue to pay you as we regularly do. That only works if you actually take the full vacation. For example, if Brianna, let's say, has been employed with her employer for 5 years, which means she's entitled to 3 weeks of vacation per year, and she takes only 2 weeks off in 2024. This means that by the end of the year, she's owed an additional week of vacation pay. And in her case, this is about $1,200 a month. Sorry, $1,200 of vacation pay, which may seem like a small amount, but over time, like, it can really add up if this keeps going. So for example, if every year you're entitled to 3 or 4 weeks vacation, and you consistently take less vacation than what you're supposed to, that means that your employer, like, there's a sort of vacation deficit every year that sort of adds up. And so make sure that, like, if you're not taking your full vacation, that you're being paid out at the end of each year. The second and probably most sort of a common issue with vacation pay is that employers, or oftentimes it gets forgotten that all forms of your compensation have to be included when you're calculating vacation pay. Because it's based on your wages, which is more than just your salary. So if you're an employee that receives bonuses, commissions, incentive payments, and things, and even room and board allowances, you get that, or that should be factored in when you're getting your vacation pay. It does not include things like tips, gratuities, gifts, and benefits. The example that I have here, if Brianna, who earns $60K a year, as her base salary, also, sorry, can you, yeah, so the example that we have here, Brianna, let's say Brianna's job is a sales job, and she earns $6,000 a year, but also entitled to commissions and bonus. She takes vacation, as we said, in halfway through the year, so 6 months in. And at that point, she hasn't earned any bonuses or commissions. And then on December 1st, 2024, so at the end of the year, Brianna's employer notifies her that she's earned $20,000 in commission and $20,000 bonus. And so, yeah, next slide. So in this scenario, as we discussed, Brianna, she takes 2 weeks off in July and just gets a regular paycheck. She essentially gets $2,500 in vacation pay. But at the end of the year, she's earned more than 60K. She's earned $100,000, which includes the $60,000 in salary, the $20,000 in commission, and the $20,000 in bonuses. And so her full vacation pay is based on a salary of $100,000 and not $60,000 for the 2024 year. And so this means that her employer has to, do a true up, which is essentially like a reconciliation or like a recalculating of her vacation pay to make sure that her bonus and her commissions were taken into account. And in this case, if you take, $100,000 and 4% of that is $4,000, Brianna would be owed an extra $1,500, which is the difference between like what she actually got and what she's fully owed. Okay. I know it's a lot of numbers at you guys, but like I said, vacation is a very, very complex area. It's not your sort of job to memorize this or to, understand all the intricate details. I think it's enough to just say that, at the end of each year, which can be a vacation year for you or like just a calendar year, you should ask your employer to give you, a full accounting of your vacation entitlements, so you can ensure that you're being paid correctly, and that all of your vacation eligible earnings, i.e., all of your salary, is being considered. And if you're unsure, if your employer gives you a response and you're unsure about it, you're not even sure how to ask, like it's worth, speaking to a lawyer or even an HR professional about how that works. Okay, questions?
Okay, so we have 2 more questions. One, so if my employer doesn't give me the vacation time, I essentially have to wait 1 year and 2 weeks, or they have to essentially wait for the 1 year and 2 weeks to have been used the following year after your first year of employment. I don't know if I read that correctly.
All right, are they asking about the fact that you have to earn your vacation over the first year?
Yeah.
Okay. So typically, yes, like that is the law, that you have to earn your vacation. So if you took vacation during your first year, for example, like based off of the legislation, it would be unpaid. You wouldn't get any payout for that vacation time, right? Because you have to earn that vacation time. I think where the issue comes in, and not the issue, is that most employers will just do vacation time. So always check your contract, but they'll always do vacation time. So they'll start with 2 weeks, which is the minimum. Remember, the ESA is the floor, not the ceiling. So they have to give you that 2 weeks, right? So they usually put in 2 weeks. And then additionally to that, it will be prorated, right? So look at the document. Obviously, we'll talk about what you should be discussing with lawyers when you're getting offers and looking at your contracts. But typically, and this is not always the case, but it is something that you see quite often, where they will prorate. So they'll allow you to take that vacation time, and then they'll include the vacation pay into the vacation time, so that you're paid your 2 weeks when you go on your 2 weeks vacation in the first year, even though you haven't technically earned it, because it is prorated. Now, if you leave the company the next year because you technically didn't earn it, it was prorated, you may have to repay that amount. So I think where it gets a little bit tricky is that most employers will just make it easier for themselves and just give you 2 weeks vacation or more, right? And if they're exceeding that, then they're paying you more than the minimums, but they'll give you at least 2 weeks paid vacation time. So that way they'll just pay you throughout your vacation and there's no issues with them trying to calculate. Now, again, it may come into issues where there's commissions or bonuses, but they should be also monitoring that and paying you adequately in regards to your vacation on those things and also statutory holidays.
Okay. Okay, I'm gonna ask the second question, and if the person could just follow up on that first question and see if it answered to their liking, that would be perfect. So if I'm on salary and my vacation days get forfeited at the end of the year, is my employer still required to pay me out for that forfeited time?
Absolutely. Yes. Assuming, yeah, I mean, assuming a lot of things, but yes. In a vacuum, yes. Like what happens sometimes is if your employer can have like if they have a vacation policy that's over and above the minimum. So let's say they're giving you 4 weeks of vacation time, and then you only take 2 weeks, and they say, they can require you to forfeit the rest of it, because like it's a company, like it's the like you're not entitled to it, it's the company giving it to you. But if as far as your ESA vacation goes, yes, they're required to pay you for the time, if you haven't taken it.
Yeah. And as a follow-up to that, as Osaro said, every company is so different. Your relationship with your company and your contract is not going to be the same as another person, even in the same company. It's very unique to you. So always review those terms before you accept and sign on the dotted line, because you could be required to forfeit, or you could not, right? Like there's cases where you get 4 weeks vacation, you didn't take the 4 weeks, and you're only in your first 4 years, and they'll still give you the vacation payout at the end of the year, right? It really just depends on the company. But if you feel like there's something going wrong in regards to your payout, or you weren't aware of these negative banking vacation policies, then definitely speak to a lawyer so that you can get more clarity in terms of whether what they're doing is legal or not.
Okay. Okay. If anybody has any other questions, you can just pop them in now. While I do this short announcement, after we finish this question period, we will have a short 10-minute break just for you to get up, stretch your legs, take in some fresh air from outside so that your brain can process all this information. And then we will be back to finish the second half of the presentation. Hello, 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 everyone. Thank you again for coming to the clinic's Workwise workshop seminar. Right now we are with Danielle Rawlinson, Osaro Obaseki, and did I say that correct, Osaro? Okay,
Yeah,
perfect.
yeah.
So I think Shannon said it correctly at the beginning too. So just before we hand the presentation back over to them, I just wanted to know if anybody had any other questions regarding vacation or anything like that that might have been missed before we went on the break. I'll just give people a moment or two to just put that in the chat. And just a reminder, if you have any questions, you can direct message me. I'm Camila. You can see me in the chat as one of the co-hosts, and I'll be able to get your question answered during one of the presentation sessions, or one of the question and answer sessions. And also there'll be one large question and answer session at the end if there's anything anyone has missed throughout the presentation. Okay. So not seeing anything yet. Okay, so I will hand the presentation back over to our facilitators. And thank you once again for showing up for our clinic seminar.
Okay, so here we have statutory leaves. And so the leaves that you see here are leaves that are provided for by the Employment Standards Act, as well as the number of days and weeks. As we've said throughout, like these are the bare minimum that you are eligible for, sort of like based on these grounds. The other thing to remember, or that I want to point out while we're on this page, is that some of these leaves, sort of like most famously pregnancy and parental leave, are have a sorry, I'll start by saying this. All these leaves are unpaid leaves. Sometimes your employer can have a policy where they pay you for some of these, if not all of them. But a couple of them, including pregnancy leave and parental leave, have an EI benefit attached to it that will pay for the leave. So even if your employer's not paying, the government of Canada might pay. The other one that's worth sort of noting is there's an EI sickness benefit leave. To know if you're eligible, either go on the website and read and or just contact Service Canada. But yeah, if we can go to the next slide. Yeah, so like I said, and said throughout, the statutory leaves are basic entitlements, and they should be provided to you upon you giving your employer notice and the required information. It's not exactly, or it shouldn't feel like a request so that you're, sort of pleading with your employer to take one of these leaves. You're entitled to them and they sort of have to give it to you. And again, they're unpaid leaves, and these are minimums. So when your employer does ask you to provide information that supports the leave, sort of be reasonable and do your best, but it shouldn't feel like an onerous process. The only time an employer can sort of ask for the world or ask for stricter requirements is when they have a paid leave policy. And so if you want to be paid while on whatever leave that you're wanting to take, then at that point, the employer sort of does have more of a right to say, we want more information or more documentation, so on and so forth. But again, if you're at a point where you need the leave and you're okay with taking it unpaid, then you can sort of assert that right and let your employer that you want the unpaid leave and not the paid leave under the company policy. And we'll touch on this a little bit more, but if your employer like directly or indirectly discourages you from taking one of these leaves, and there's a number of ways they can do that, including reducing your hours or changing your schedule, this is grounds, or this is what we call reprisal, which is grounds for a Ministry of Labor complaint.
Perfect. So perfect segue into our next discussion topic, which is the Ministry of Labor complaint. The Ministry of Labor is a body that essentially oversees and ensures that there's fair and equitable treatment and practices that employers are adhering to. And it's a body that kind of promotes social and economic harmony and justice within Ontario. Ministry of Labor complaints are claims that are filed with the Ministry of Labor by employees who believe that their rights under the Employment Standards Act, or the ESA, have been violated. Some of those types of violations are unpaid vacation or holiday pay, unpaid wages, including overtime. So if your employer has not paid you overtime that you're rightfully entitled to and owed, not providing an employee with time off for an entitled leave of absence, as Osaro had just mentioned, not providing an employee with a record of employment, T4, or any other required employment document, and reprisal, which Osaro has just mentioned again, and we'll go into that a bit deeper in the upcoming slides. So that's penalizing an employee for exercising, inquiring, or pursuing their rights under the ESA. So employer reprisal. It's important to know that an employer can't penalize or threaten to penalize you in any way for inquiring about your rights. This includes asking them to comply with the ESA, asking questions under the ESA, filing a complaint under the ESA, which we'll talk about in a moment, participating in a procedure under the ESA, exercising or attempting to exercise a right under the ESA, providing information to an employment standards officer, disclosing to another employee your rate of pay, or asking another employee to disclose their rate of pay to determine pay equity, taking or planning to take an eligible leave of absence, being subject to garnishment, or participating in a proceeding under Section 4 of the Retail Business Act, Holidays Act, which essentially is related to certain businesses being open on holidays, certain retail businesses, such as malls. If you do any of the aforementioned actions, so if you take part in any of those proceedings or any of those types of claims or any of those types of inquiries, your employer, under the legislation, cannot punish you, cannot reduce your rate of your pay, cannot intimidate you, cannot suspend you or terminate you or penalize you in any way or threaten any of the above. That being said, what is in the legislation and what is known to be true in the law sometimes is not done in practice. And unfortunately, employers may just do these certain things. And that's where you would enlist the assistance of the MOL potentially. And an employment standards officer can order the employer, if they do these things because you have taken part in any of the previous actions, to reinstate you. That means bringing you back to work if they fired you or laid you off, and compensate you for any losses incurred due to the ESA violation. So the time frame for bringing an MOL claim, which is a Ministry of Labor claim, is within 2 years of the alleged ESA violation, in order for the employment standards officer to investigate your claim. So that means if you were supposed to be owed overtime within the last 5 years, it would only be the last. If your last instance of a missed pay was past the last 2 years, then the employment standards officer would only you would have to file anything that's new or upcoming within the current 2 years, essentially. So this is called a limitation period. You have to make sure to file whatever claim you have based off of the alleged violation within 2 years of the date of that violation. And then the recovery period, which is not the same, but in the similar vein, is in regards to time period. You can only recover unpaid wages, that is overtime, any other kind of unpaid wages that are owed to you within the 2 years before you filed your claim. So you can, if you filed your claim the date of the last instance, then if there are any other unpaid wages within the 2 years prior to that, then you can also recover those amounts. So what information or documentation are needed to file a claim? Again, documentation is always important when filing a claim, when dealing with any legislative body, when dealing with lawyers. And what they would need at the MOL is the last pay period that you had, whether you're paid hourly or salaried, how often you're paid, weekly, bi-weekly, monthly, etc. How you're paid, whether you're paid in cash, by check, or direct deposit, how much you were paid, and how many hours you worked, your contact information, your employer's contact information, and any other supporting documents regarding the claim. So for example, if it's overtime hours that you're claiming, if you've documented the times that you've emails where you're working overtime and it's time stamped, right? Or if you've actually accounted for all of your overtime in a documented spreadsheet, those would be very useful pieces of supporting documents. So the process in filing a Ministry of Labor claim, after you file the claim, so you can file the claim online. There's a process that you can file through the Ministry of Labor website. An employment standards officer will contact you and or your employer to gather any further evidence for the complaint. So if you have a lot of documentation in regards to your notes, and you've outline on a spreadsheet the hours you worked every day that were overtime, for example, or the hours that you worked on a holiday that you weren't paid for, that's great. But sometimes the employer might have further evidence or information on Slack or other types of tools that they use to count your hours, things of that nature. So you don't have to feel super stressed if you don't have all of that information, because the officer will reach out to your employer to gather any information that they have in their possession. Obviously, we would want the employers to be honest in regards to providing that information, but the employment standards officer will definitely contact them to get any further evidence. Once the officer gathers the evidence, then they will conduct their investigation. This can take a range of amount of time. We cannot say how long this will take depending on the officer, their caseload, the complexity of your claim, etc. But they will conduct their investigation and then will provide you a decision on your claim. So that's whether you're entitled to the unpaid wages or the recourse that you're seeking. So Ministry of Labor complaints, there's a lot of pros. Again, this is a very easy process for employees to pursue with no filing fees and without legal representation. So as long as you have your documents and you know what you're seeking, definitely you can bring a claim on your own. The process is more investigatory and less adversarial or formal. It's not like a tribunal or a trial where you'd be going up against your employer. Typically what happens is you'll file the claim for a certain amount based off of what you're saying is owed to you under the ESA, and they will start the process of the claim. And typically what happens is the money that is supposedly or allegedly owed to you will be put into like a trust. So the employer has to put the money there. And if it is determined that some or all of those monies are owed to you, then it just goes to you automatically. So it's kind of, the onus is on the employer to, have merits to the point that there is nothing owed to you, right? The onus is on them to defend that. If you're still working for the employer and you're only owed some unpaid wages, it may be a quick and efficient process as opposed to bringing a claim through the court system. The employment standards officer will do most of the work. So once you provide them with the evidence, they'll do their calculations, they'll go through the case law, they'll do a lot of the background work for you to make sure that whatever is owed to you, if there is anything is owed to you, will be paid to you. So just make sure you're providing them as much information so they can conduct a really deep dive in terms of, they can do a good deep dive in terms of that evidence to assist them in their investigation. Now, some of the potential cons or not so great parts of the Ministry of Labor complaint is that employment standards officers aren't legal representatives. They're not lawyers. They haven't practiced as lawyers for the most part, and they only provide you information on your minimum entitlements under the ESA. So this is your minimums under the ESA, such as vacation time or vacation pay owed, holiday pay, vacation pay, and also overtime pay. So these are a lot of things, anything that's owed to you that the employer has to provide to you under the Employment Standards Act, and you can only recover those entitlements under the ESA. So for example, if you were terminated by your employer and they're still owing you vacation pay or overtime that they didn't provide to you, and that's all you really want to recover from them, then you can bring a Ministry of Labor complaint. But if, for example, you're terminated and you were given a severance package, and we'll talk about this, Osaro will talk about this later on, but you were given a severance package and it provided you your minimums, but you're looking to get more than that, the employment Ministry of Labor cannot assist you with that. They only deal with anything that's entitled to you under the ESA. And again, the last thing, and a really big con, unfortunately, is that there's employer reprisal as a huge possibility. We would hope that the relationship between you and employer are decent enough and cordial enough that if you do bring a claim, they will look into it and then reimburse you whatever it is that they're owed to you. But oftentimes employers may take it personally, or they may have whatever reasons they have that they may treat you differently or adversely at work if you bring a claim and you're still working there. Some of them have gone to the extent of firing employees for bringing these types of claims, right? And that's where we'll continue on talking about terminations in the next upcoming slides and how you can get some recourse in that regard. So our Ministry of Labor complaints your only option for your employer's ESA violation? No, right? As I said before, if you're only seeking your minimums, then that's a good avenue. But there are other avenues to seek recourse if you believe that your rights have been violated. You can speak with your employer first and foremost to have them rectify the violation without having any intervention of the MOL or a lawyer. And if you do have to go further than speaking to them and pursue a claim, you can also pursue a claim through the court system under the common law. You can't simultaneously file a Ministry of Labor complaint as well as pursue your claims through the courts. So if you do pursue your right through the court system, you have to make sure that you withdraw your Ministry of Labor claim within 2 weeks of its filing. And again, always speak to a lawyer before making a decision. Even if you're going to represent yourself at the Ministry of Labor or any other avenue, make sure you talk to a lawyer to get some legal information at the very least, and legal advice at least, and legal advice for what's the best avenue for you? What can you be potentially entitled to? What are some of the pitfalls of your claim? What are some of the strengths? It's just good to understand what's the best strategy and decision for you to go through, and a lawyer can give you that specific information and advice for your specific incident, complaint, claim, or termination with your employer. And if we have any questions.
Okay, so we have one question. Does the ESA apply in part or entirely and in its entirety to workers whose company is not federally regulated, but the company was federally incorporated? For example, the company does not give bereavement days as they advise the business is federally incorporated, which does not have a requirement to provide bereavement days. It's a bit of a mouthful. If you want me to reread it, I can do that.
So, sorry, did you want to say something, Osaro?
No, you can go first.
So you have to be regulated under one of the legislation, like regardless of whether you're federally incorporated, but you have subsidiaries or other offices in other provinces, and therefore that particular province is under a provincial legislation or not, you have to be regulated by one or the other. So either you're regulated under the legislation of the province, regardless of the province, they all have their own employment standards acts or codes, or you're federally regulated under the CLC. So you have to determine which one of those you are. And if your employer is not willing to provide you that information, you could potentially go to a lawyer and maybe they can do a corporate search, or you can try to do it on your own to figure it out. But either way, they have to be regulated under either the CLC, the Canada Labour Code, or an Employment Standards Act or code.
Yeah, that's right. And my guess is that the employer either like misspoke or was confused in that. Yeah, I don't know because like whether or not you're incorporated via an Ontario, statute or I think it's like the CBA, the Canada Business Act, that doesn't affect, like the employee at all. It's just the undertaking of the business. And so like Danielle said, you're either federally or provincially regulated. And so bereavement leave is definitely in the Ontario legislation. I don't know off the top of my head if it's in the CLC. But I'm guessing that they meant to say that it's not. But yeah, I would double check that.
Yeah.
Okay.
It's always good to just get clarity with the employer. Sometimes, unfortunately, they don't know themselves, or not to say that they're leading you astray, but they just want to give you the easiest answer that you won't follow up with, right? Because they don't want to give you a leave, for example, right? But it is incumbent upon them to provide the right information, and if they don't, then you should make sure that you get the right information. Yeah.
Sorry, I didn't cut you off. Go ahead.
I was gonna say, and if, for example, it's your boss, i.e. your direct supervisor or manager giving you this information, maybe go to HR so that they can provide you with the accurate information if you have an HR.
Okay. The person said they're a lawyer, so they know. I guess the boss. So that should be an interesting conversation.
So yeah, so it's giving the vibe of I'm just gonna kind of high level answer something because I don't want to like provide the right information, because there has to be a legislation that governs your employment, regardless if they're lawyers or not. They should know that. And whatever legislation governs your relationship, that is what they have to abide by in terms of the minimum requirements.
Yeah. And in the event that it is, I'm guessing it is that they're federally regulated and there isn't bereavement leave under the CLC, there's a list of leaves there. If not that one, like there might be an equivalent or one that you could rely on. And so if that's the case, and you're eligible for another leave, I would look up the list of leaves and be like, okay, well, I want to take, X leave on X grounds. Yeah.
Okay. I said thank you. Okay. We don't have any other questions, but just reminding everyone to send me the questions directly, and there'll be a larger question and answer period at the end of the session. Okay, thank you. You can continue.
Okay. And so one of our final topics, which is, always a difficult one, is termination of employment. And before I get into it, I'll just say that, this, the presentation generally, but like this sort of part generally, it almost exclusively applies to unionized employees who are non-unionized employees who are provincially regulated in Ontario. So, the Employment Standards Act, as we've been talking about, if you're, federally regulated or a member of a union, there's a whole different set of considerations. And so, yeah, just sort of keep that in mind. The first line there, an employer has the right to terminate an employee. That's specifically true here. Provincially regulated employers have very wide discretion to end an employment relationship, as they see fit. There are a few exceptions to that. Obviously, things like human rights, bad faith, so on and so forth. But for the most part, as long as it's not a really, really bad reason or done in a way that's that's sort of let's say you get an injury and the employer doesn't want you to make a work safe claim or WCB claim. As long as not something like that, then an employer can sort of terminate an employee whenever they want to. There doesn't always have to be, or employer isn't necessarily obligated to give you a reason as to why they're terminating you. It's obviously best practice to do so in some capacity, but when they're doing that, this is called a without cause termination, which means that the employer, for whatever reason, has decided to end the relationship. And when they do that, they don't have to give a reason. What they do have to do in most cases is give you your statutory entitlements under the ESA. And this is again one of those things that's like a general rule that applies for most people, but then there's certain circumstances and cases where they don't have to do this, and we're going to talk about that. Okay, so as far as statutory entitlements, there's like two sort of broad ones that we have to think about. The first one is what we call statutory notice. And this is this amount is basically 1 week per year based on your years of service, up to a maximum of 8 weeks. And that first bullet point there says statutory termination pay, which is what it is when an employer decides to pay you out. But this particular entitlement can be provided as like working notice or pay. And so when an employer decides to give you notice, it's called statutory notice. And then when they decide to pay you out, it's statutory termination pay. This period, it's 1 week per year, up to a maximum of 8 years. Well, it's actually after 3 months you're entitled to 1 week, and then after 1 year entitled to 2 weeks, and then eventually it's 1 week per year. There is during this sort of stat notice period is what we call it, the employer has to continue your benefits. And then any unused and unpaid vacation pay must be paid out at the time of termination. So, and I've talked about vacation for a while before, but if nothing else, make sure that your employer is giving you like a very detailed explanation of all the vacation that you've taken and all the pay that you've gotten, and making sure that you so that you make sure that you're leaving with your full entitlement. Because what happens sometimes that an employer, if they've been assessing vacation incorrectly or not realizing that you it's easy for there to be a mistake or an oversight as to a vacation practice or your vacation pay. But this is the one time where they should be going back and making sure that everything is squared up in terms of your vacation pay, and taking into account all of your compensation. So next slide. So the other entitlement, along with statutory notice, that you are that the ESA that your employer should be giving to you, according to the ESA, is statutory severance pay, and this is for employees who have worked for an employer for 5 or more years, and this amount, unlike the last one where it can be a notice or pay in lieu of notice, this one must be paid out, and the amount is 1 week per year of service, but it also takes into account how many months that you've worked with an employer as well, and so it's actually 1 week and then a prorated amount for months. It's a very complicated calculation that a lot of employers sometimes sort of mess up, and so this is another area that you should definitely be seeking a lawyer on, or second opinion on, to make sure they're doing it correctly. And the cap for this is 26 weeks, regardless of how long you've been there. And so between the maximum 8 weeks of the stat notice period and the maximum 26 weeks here, the total that you can get, or the most that you can get if you've been with an employer for 30 years, 35 years, whatever the case may be, is 34 weeks under the ESA. So yeah, all that said, there are certain circumstances, situations where an employer doesn't have to give you that. The most common one is when an employee is guilty of what we call just cause. And there are two standards for it. One is the sort of wording that you see here: willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. This is a very specific uh, um, legal term that has, a very significant sort of meaning. I think for, purpose of today, like what you should know is that this is a very, very, very high bar that's, hard to meet. And if your employer is not, you should always seek legal advice, but if your employer is not paying you your ESA entitlements, termination entitlements, because they're saying you've been fired for just cause, immediately, like alarm bell should be going off in your head, and you should be going to a lawyer to seek advice on this, because this is a very very high bar. The other scenario, certain sectors, construction, building maintenance, and then construction of roads and sewers and pipelines. There are certain construction workers that aren't entitled to it. And then if you're an employee who refuses a reasonable alternative employment with the same employer, sometimes you're not entitled. But again, that's very sort of like that's a very legal specific sort of position that an employer would be taking. And so definitely seek advice if your employer claims that. And then frustration of contract, which is essentially when the employment contract or when the employment relationship has to end because of the circumstances, or because of circumstances that are outside of the control of the employee and the employer. And so things like, if your the classic one is like if your place of work, if the building that you work at was struck by lightning and now it's destroyed, things like that. What's not included in that is disability. If you get into you're injured and you can no longer perform your job because of your injury, an employer can't say that that's a frustration of contract such that you can't get your ESA requirements. If the employer eventually decides that or you and the employer decide that you can't come back and the employment relationship has to end, they do have to give you your entitlements in that scenario. The other scenarios where ESA might not be required, if you are a fixed term employee or you were hired to do a specific task, you're not entitled to ESA notice, but you are still entitled to severance. If you're an employee who gets laid off and then gets called back from a layoff but doesn't but decides not to come back, you're not entitled there. Mandatory retirement, as long as it complies with the Human Rights Code, you're not entitled to ESA severance. And then if you are terminated because of a strike or a lockout. Okay, and so all that was just the ESA and statutory entitlements. The other kind of entitlement that you could be entitled to is common law. And at common law, there's no you lose your common law entitlements if you are fired for just cause. Again, just cause has a very specific legal meaning. It's not always, and actually I would say that it's rarely can you establish it off of like a single act unless it's something that's just absolutely, devastating to the employer, the employment relationship. It's a very contextual approach to deciding when there's just cause. The sort of most important principle in assessing just cause is that the punishment should be appropriate to the conduct. And again, what conduct and what the punishment should be really depends on so many things like the workplace, how long you've been there, like your disciplinary history, the employer's policies and what they communicated to you, what's generally accepted in the workplace, and things of that nature. And we have some examples of just cause here: child pornography, a serious driving accident while impaired, misappropriation of company property, sexual harassment, multiple sexual relationships with subordinates that become disruptive to the workplace, and dishonesty that might impact the trust of the employer relationship. Always seek legal advice when you are terminated for cause. The examples that we listed are definitely could be grounds for cause, but they also could not be. It really just depends on, like I said, a number of factors. And then as far as common law goes, when you're terminated without cause, there are three things that you should be thinking about. One, your statutory entitlements, which is what we just talked about, your ESA notice and severance, and whether or not you're getting those. Your contractual entitlements, which essentially says, many contracts have some sort of termination provision that either say you get, the ESA minimum and nothing more, or you get some sort of formula. But don't presume that just because your contract says that you get something that that's all that you get. And the third one is your common law notice, which is again like a sort of legal equation that takes into account your length of service, your age, the type of job you have, market factors, and the economy. And what you're entitled to depends on really it's very person specific, but the starting place is your contract. And so, like I said, I've said throughout, and like we'll continue to say, if you're ever in the situation, seek legal advice. The other scenario that we thought was worth talking about was constructive dismissal, which is a type of termination that has two elements. The first is that the employer unilaterally imposes a change, which means that they're changing something about your employment without your consent. That's a fundamental term to your contract. Examples of fundamental terms are, your salary, how much you're getting paid. And we have 5 to 10% there because, the idea is that even if it's a fundamental term, if it's a small change, it's not necessarily, a fundamental altering a fundamental term. But if it's, the number that we have here is 5 to 10%, if it's significant, then it is a change. Reduction in hours, again, it's one thing if your employer says you're going to work 37 and a half hours a week instead of 40 hours a week. But if they say you're going to work 30 hours a week instead of 40 hours a week, that's significant. Location of work, same kind of thing. If your employer moves you from Toronto or from downtown Toronto to Eglinton, you probably don't have a claim. But if it's, a significant change, and that could even just be within the GTA, like that might be grounds for constructive dismissal. A poisoned work environment, that's when your employer is, failing to address concerns in the workplace, whether that be, bullying, harassment, sexual harassment, and things of that nature. A demotion. So that this one often comes up in things like, reporting structures, or, you're leveling in the company. So let's say, you're a supervisor and you're managing a team of 5 people, and then all of a sudden you're no longer managing anybody. That can be constructive dismissal, and then changes to benefits and perks. So in order for the second sort of element of constructive dismissal, is the change has to be such that a reasonable person would conclude the employer no longer intended to be bound by the employment contract. And what that really means, that's all just, legal jargon for saying that the change has to be something that, like looking at it objectively, you would think it's no longer the same employment relationship. Like the position that I got hired to do, I'm not doing it anymore. It's because it's so different. Next slide. So when this happens, you may have a recourse in the form of a wrongful dismissal action. And our advice is to, our recommendation is to seek legal advice to determine if you are potentially entitled to more than was offered to you when you were terminated. And if the package that you received was a fair one. The other thing that you should do is definitely seek advice if you were terminated for a cause, or you believe you've been contractually dismissed. The termination for cause one is sort of obvious, but as far as constructive dismissal goes, like if your employer is making either, has made a big change, or is even making like subtle small changes to your employment over time, and you feel like you are, being forced out of a position, or being demoted, or so on and so forth, they're being, slowly underpaid because they've changed. It could be a bonus structure, it could be commission structure, it could be your hours. Seek legal advice, because like it might be the case that, that what the employer's doing, even though they haven't said that you're terminated, is, sort of like tantamount or equivalent to a termination. Yeah, so if you're in any one of those scenarios, always seek to schedule a consultation with an employment lawyer, either immediately after termination, or at any point. Sorry, no, not at any point. Immediately after termination, if that's what happens. But if it's a constructive dismissal, you want to do it. You want to move as quickly as possible. And so, yeah, when the employer makes a change, ask them about it, push back if you think that that's necessary or appropriate. And then if they say, we hear your concerns, but we're not going to change it, or we've already decided this is what it's going to be long term, then you want to seek a lawyer as quickly as possible, because there are potential sort of consequences if you wait too long to sort of make a claim. There are many law firms who provide complimentary consultation to determine whether or not you have a claim or you've been contractually dismissed. Me and Danielle both have worked at law firms where these were free, and I think that this is an important point, because I think a lot of people think that even to get advice on whether or not you have a claim might cost you something. That's not true. Lots of lots of law firms do have a system for taking on for taking on potential claims. and having an intake system that where you get advice for free. And lawyers are honestly generally happy to do it. And we'll talk about, how to best go about that in a little bit. And if you are terminated, and you are provided with a deadline to sign the severance package, usually in exchange for, something that's over and above your minimums. Best practice, or our suggestion would be to speak with a lawyer before you do so. If there's any sort of difficulty or delay in getting to a lawyer and you need more time, definitely ask your employer. It's not always the case, but like in my experience, many employers will give you a little bit more time. And so don't hesitate to ask if you're in that scenario. Um, and yeah, next slide. So when you do end up sort of meeting with a lawyer, scheduling an appointment, it's really important to be as organized as possible, especially when it's free. You want to get your bang for your buck, and make the most of that out of that time. And to do that, like you want to provide as much information as possible. We have a list of things here: the date of hire and the termination date, age, your role at the company, offer letter, compensation breakdown, the termination letter, and then a brief overview of what happened. Generally speaking, the more documents, the better. Don't go crazy because, you don't want, somebody to be reading like a 300-page, summary by you as to like all the things your employer has done. Realistically, like at this stage, like that's probably not going to be reviewed anyways. But you want to be organized. And yeah, and at that point, like that really gives or puts the lawyer in the best position to give you preliminary legal information or advice on how to best move forward. And if you meet with that lawyer and then you end up retaining them, they will sort of take over communication from there. And what they typically do is they attempt to resolve your matter with settlement negotiations. And then if those don't work out, or like the employer isn't willing to negotiate, then they may bring a claim on your behalf. And where they bring the claim, whether that's through the court system, the Human Rights Tribunal, the Ministry of Labor, will depend on the circumstances. But I also say that like the relationship should be one where you are they're sort of advising you of your options and the different ways they can go about it, and that you're ultimately making a choice. I think that pick a lawyer that you trust and that you're comfortable with them, like sort of driving the litigation. But I think it's also like smart to be involved and informed, and that's what your lawyer is there for, is so that you can ask questions, and that they can move your claim through the sort of court process or through the legal process in a way that aligns with like what your goals are. And of course, no lawyer can guarantee an outcome. That's just the nature of law. Decisions are made by judges or adjudicators who are human beings, and they even amongst themselves disagree all the time on like how some things should go. And so yeah, just kind of keep that in mind as you're going through the process. And when it comes to wrongful dismissal in the courts, there's really two main types. There's a without cause claim, which is when you're just arguing about the severance package that was offered and why it wasn't sufficient. These claims are relatively sort of like easy for, you know, employees to go through, relatively, because we're not talking about, you know, your we're generally not talking about, you know, something that you did wrong, like in the for cause case that we'll talk about in a second. It's really just about like money amounts, notice period, mitigation, um, and whatnot. And then the other type of claim is a for cause claim, which is when we're saying that, you know, the employer terminated you and didn't pay you any severance because, you know, they're saying that you did something that like disentitled you from that severance. And those claims are much more involved, expensive, difficult for both sides, typically, so on and so forth. Um, uh, in the civil claims process, sometimes Ontario, you can sort of like tack on a human rights claim and other damages to your civil claim. So, for example, rather than, let's say, you know, you felt you were discriminated during or as a result of your termination, and then your employer ultimately terminated you, rather than bringing like two claims, you know, one at the Human Rights Tribunal and one via this civil courts, you can bring all of those or both of those claims like just through a civil action. And as far as time limits goes, it's as Danielle said, for MLO complaints, generally 2 years within 2 years of the termination or constructive dismissal. And there are two sort of major claims or claim thresholds. There's the small claims court, which for claims that are less than $35,000, and then there's the superior court, which is $35,000 and up. I will say that, you know, there are some times what an employee can do is bring a small claims action that's worth $35,000 more, or sorry, worth more than $35,000, and sort of abandon the claim, abandon the portion of the claim that's worth more than 35K. So let's say your claim was worth $50,000 and you say, I'm only seeking 35. And the advantage to doing that is that small claims typically faster, easier, and if you're gonna, you know, represent yourself, it's much easier to manage a small claims action as opposed to a superior court, because the processes are just simpler and more accessible.
So with all of that information in regards to terminations and the fact that we've reiterated several times to speak to a lawyer, when should you actually speak with a lawyer? Like, other than when you're terminated or potentially harassed or discriminated. We advise and we suggest that you would, you know, speak to a lawyer during the hiring process. So when you're negotiating the terms of your contract, whether that's your compensation, benefits and bonuses, vacation time, any kind of contractual terms that include privacy or IP rights, or even inclusive of things such as non-competition, which is really more so for very C-suite employees. But just the fact that, you know, your contract may have a non-competition, which it shouldn't if you're not a C-suite employee, because they are prohibited. It's just good to, as a good general rule, have a lawyer review your contract before you sign it, because then you know, what you're getting into, right? Because sometimes there's legal jargon in contracts, but also you kind of understand what your potential recourse is once you get terminated, right? A lawyer can go through your whole contract, including your termination clause, if there is one in your contract, and kind of give you some legal information or even advice on, you know, what is a potential outcome if X, Y, or Z happens in your employment. So it's just good to have an overall view of what your contract looks like, what your relationship is with your employer. Once you sign on the dotted line, it's pretty much set in stone for the most part. I mean, obviously through litigation and claims, There's always gray areas in employment law, but for the most part, once you sign something, you're signing an agreement to it. So prior to signing and negotiating your terms, when you have the power during negotiation, speak to a lawyer and have a contract review. Also, if you have any questions regarding what a prospective employer can ask during an interview, if you had an interview with a prospective employer that some of the questions you felt were out of line or discriminatory, it's good to have that conversation with a lawyer as well. During your employment, you should also speak to a lawyer if necessary, if you feel like you're being constructively dismissed. I can't tell you how many times I've seen people just resign and then come to me once they've resigned and say X, Y, and Z has happened and this is why I left. And there was a lot of, you know, issues in regards to their relationship with their employer. And again, with law, nothing necessarily, there's always caveats and things of that nature when it comes to, you know, resignation, but typically, as per the legislation, you're not entitled to any severance if you resign. You're not entitled to EI. So if you're resigning because you feel forced out, before resigning, I would definitely suggest that you speak to a lawyer. If there's harassment and discrimination, including seeking accommodations, speak to a lawyer. They can help you navigate those conversations with your employer or bring a claim if necessary to the appropriate adjudicators or venues. As well, it's just good to have the conversation if you forget what we've talked about today, just in case, in terms of what kind of information you should probably be documenting. Even, for example, if there's an issue where there's an investigation and you don't feel comfortable attending an investigation interview by yourself, you can have a conversation with a lawyer how to best navigate that, or even retain their services to assist, to be there on the investigation call with you to kind of provide support on the process. Also, if you are getting raises or promotions, sometimes that does come with a new contract, so then you would want to review that contract again, specifically because if there's changes in the law and changes in legislation or changes in the drafting of your contract, it could change your employment status completely, or it could change, you know, your termination, what you have upon termination in terms of entitlements, etc. It's not always the case, but always if you're getting a new piece of documentation that you're required to sign, and they're giving you some kind of what we call, they're giving you money for it, or they're giving you a promotion, they're giving you a raise, then you should definitely see a lawyer. And right after you're terminated, of course, always seek legal advice after you've been terminated, or when you receive a termination letter. Some people are terminated and they don't receive a termination letter. Still seek legal advice. Regardless of if you think you were given something good, you could be entitled to something more that you're not aware of in terms of a severance package, if it's without cause. There's just a lot of different legal thresholds and requirements that employers have to provide to you when you're terminated without cause. So it's always best to make sure that they are adequately paying you out and providing you with those entitlements. And of course, for cause, as Osaro said, the threshold is just very high, and the types of for cause allegations are very gray in terms of what is and what isn't. So don't ever assume that the employer is right to terminate you and not pay you anything because you've done something quote unquote wrong, or that it was misconduct. So those are times when you should definitely speak with a lawyer, not only when you're being terminated, but during the course of your employment, just to make sure your rights are being upheld. So there's a few resources that we have compiled that we think are useful for you guys to have as Black folk navigating your employment. And one of them is a lawyer who's a former colleague of mine at my old firm, and she is an employment lawyer. She is a Black woman and she is excellent, and she has given her consent to provide her information. So if you have any employment law issues, feel free to reach out to her, and you can let her know that you received her information from the clinic's presentation. And the Black Legal Action Center, Black for short, they provide summary advice and referrals to employees for employment standards, WSIB claims, and wrongful dismissal matters. So that's their information and website. Ontario's various legal clinics. These are clinics that are all across Ontario in the different regions. And they do have legal thresholds, income thresholds rather, in terms of most of these clinics do help those who are low income or lower income, but always just seek what their threshold is if you are going to a legal clinic. And they actually offer you legal advice and representation. And so they assist people who cannot obviously afford to go to your typical lawyer at a law firm. And this link that we've put here is for all the clinics. So you can just search by your region or your location to find a clinic. And then the last resource is Steps to Justice. I find this very useful and practical for people navigating any employment issue, any legal issues, but employment law for sure. And they have guided pathway videos to show you how to navigate small claims, for example, or filing a claim. They provide you information and tools to help you navigate those issues. It's just a very useful, practical, hands-on tool that will, at the very least, give you the basic information that you need. I would always say still seek legal advice, but this is a very good tool. So these are probably the top 4 for our community that we would recommend. Oh, sorry, there's more. Yes, also the Ministry of Labor. Sorry, these are linking back to the topics that we covered. The Ministry of Labor, of course, this is their website and their information. The website helps you navigate all types of issues under the Ministry of Labor, including employment issues, leaves of absence, overtime. It covers pretty much all of the topics under the ESA. And also can assist you in Ministry of Labor claims processes. And then we have the Ontario Human Rights Tribunal. There's their information and contact information. The website has a very generous amount of information in terms of how to start a proceeding, what to file, where to file, what they base their decisions on. It's very informational. It's very good. And then adjacent to them is their Human Right Legal Support Center. So this is the center that I was talking about that essentially can review your documents with you, kind of go through the high level of your claim. They could potentially provide some legal assistance, but mostly it will help you get a high level of an understanding of your claim and the strength of your claim, which is important to know, right? What evidence you may need that you may not have. And it's just a great resource in helping you navigate as a self-represented individual at the HRTO.
Okay, so thank you very much for the presentation that you guys have provided. We do have one question in the chat right now, and as I kind of read out this question, if you all have any other questions, please directly message me, Camila, in the chat, and I'll read them out to our facilitators. So our question is, can an employer legally prohibit an employee from having a second job?
No. You're entitled to have a second job. You have to look to your contract. This is the main thing, right? There are certain contracts that have moonlighting clauses, or the typical contract will have something that says, if you do have other work outside of this employment, it will not impact your availability to work the hours you're supposed to be working at this job, right? So you have to look at your contract. If your contract says something like to that effect and you've signed it, then you need to have a conversation with a lawyer, right? Because unfortunately, there's things in employment contracts that are not necessarily to the standards that they should be, or meeting the standards. Obviously, if it's an employment standard, then it's illegal, but there are certain things that you sign that employers incorporate that you have now bound yourself to because you signed the contract, right? It's not necessarily illegal or not illegal, it's just questionable. And so that's one of those things. There are contracts that have moonlighting clauses. Sometimes there are clauses specifically to the same industry. So you just have to be very cognizant of that. And I would say look at your contract and have that conversation. And if it's not in your contract, then you can tell your employer, like, as long as I'm not affecting my job, I'm coming in my 9 to 5 or whatever the case is, and I have my other job, that's totally fine. But if there is something in the contract that says the otherwise, then have a conversation with the lawyer and see what they can do to help you navigate that situation.
Okay, thank you very much. Anyone else? Do we have any other questions? Okay. I don't see any other questions in the chat. I'm just gonna let our tech go back to the resources page, and I will hand it off to Shannon, our founder, to close us out for the afternoon.
Okay, so I just want to give a special thank you. Is my camera on? I don't even know.
Yes, it is on.
Can't see myself. All right. Anyways, so I just want to give a special thank you to Danielle and Osaro for their very comprehensive presentation. I want to thank all of you for spending time with us today. Hopefully this information was helpful. I know it could be a lot to digest, so this will be uploaded to our website for you to go back and review at a later time. And the presentation will also be uploaded as a PDF so that you can have the information at your fingertips and kind of go through it at your own pace. You can look for that to be on our website later on this week. We'll also put an announcement on our social media. If you're not following us, our handle on Instagram is @_the_clinic_. And we are also on Twitter and Facebook, and you can find all of those links from our Instagram page. And I think you can also find it on our website, which is www.thepublicclinic.com. In addition, we have a lot of other programs planned for this year, all kind of in the same realm of employment. So we're going to have a career advancement clinic later on this year where we'll have professionals come in and sort of give guidance on how to sort of elevate your career if you're trying to move into another area, like what are some best practices, hopefully be able to, help you work through a resume or cover letter and give you some tips on how to make yourself stand out in the job market. We're also going to have some sessions for entrepreneurs to, get some guidance, some inspiration, and some clarity on how to maybe get started with some ideas that they have. And we're also going to have some social events that you can come out to and connect with us and connect with other people within the community and just feel a sense of belonging and things of that nature. So we hope that you will continue to come out and support. And, we're always here to answer questions or to provide information or resources. And if we don't have the information, we'll always try to find it, look for it, and provide it to you. Also, just a special treat for everybody that came today. Tomorrow, you will receive a code in your email for Uber, either you could use it toward an Uber ride or Uber Eats, just as just a token of our appreciation for you coming out and supporting us. So you can look for that tomorrow in your emails. And I think I have covered everything. If there's any questions with respect to anything that I just said, please let me know. Otherwise, our session has come to an end, and I thank you again for joining us today.
Thank you for having us.
Thank you. All right, everybody, take care.
Thanks, Shannon. Thanks everybody for coming.
Thank you. Thank you.